Friday, and the tape nobody was supposed to hear just went public. The consequences just started showing up. 18 minutes. That's how long the recording runs. And in those 18 minutes, everything Melania Trump's legal team spent months building collapsed. 4 days since this story broke. Here's what's already changed. Pam Bondi released evidence she was never expected to release. Melania's attorneys filed emergency motions and lost. Donald Trump's inner circle went completely silent overnight. But that's just the surface. The tape doesn't just damage Melania. It puts Donald Trump in a room he cannot explain his way out of. I'm going to show you who this actually hits. Not headlines, real people, real legal exposure, real consequences. 3 groups getting crushed, 2 investigations expanding, 1 piece of evidence that changes everything. Let me break it down. What's happened in 4 days? Melania's legal team filed emergency suppression motions within hours of the tape's release, all denied by Friday morning. 3 attorneys have reportedly requested to withdraw from the case. Trump's inner circle, at least 4 senior advisors, stopped communicating through previously used channels, phones going dark, meetings canceled without explanation. The former DOJ's narrative, Pam Bondi's critics insisted she would bury damaging evidence to protect Trump loyalists. The tape's release destroyed that argument completely and created a new one. The reaction across Washington? Congressional oversight committees requested the full unredacted transcript by end of business Monday. 2 Republican senators broke publicly from Trump on this specific issue, the first cracks in months. Legal analysts across every network revised their assessments within the same news cycle. Federal investigators confirm the tape is authentic, chain of custody intact, no manipulation detected. The former DOJ under Bondi signaled more materials are queued for release. This was not the final drop. That's measurable fallout in 96 hours. Now let me show you the deeper impacts nobody is connecting yet. Fast recap for anyone who missed days 1 through 3. Day 1, the existence of the 18-minute tape leaked through a source inside the former DOJ. Melania's attorneys immediately called it fabricated. Day 2, Pam Bondi confirmed the tape was real, authenticated, and had been sitting in secured evidence storage. She announced it would be released in the public interest. Day 3, Trump's team attempted to obtain a court injunction to block the release. The judge denied it in under 4 hours. Day 4, today, Bondi released the tape. The world heard it, and by Friday afternoon, nothing looks the same. That's the sequence. Now, who this affects beyond Melania and one recording. A Trump advisor reading emails in Florida right now, affected. A Republican senator facing re-election in 18 months, affected. A federal prosecutor who thought this case was finished, affected. Every future First Lady with private communications, permanently affected. This isn't political drama. This is a legal earthquake with aftershocks nobody has mapped yet. Subscribe. This analysis goes deeper than the headlines. Donald Trump and the network of attorneys, advisors, and intermediaries who shape strategy around the communications now captured on the tape. Directly, Trump's core legal team of roughly a dozen people. Indirectly, every advisor who was in the room, on the call, or copied on communications connected to what the tape reveals. The tape places Trump's awareness of certain decisions at a time his legal team has publicly insisted he had no knowledge. That is not a minor inconsistency. That is the foundation of obstruction exposure. Attorneys who crafted statements contradicted by the recording now face professional responsibility questions. Bar complaints are already being drafted. Any parallel civil litigation touching the same subject matter just got a primary exhibit handed to opposing counsel. Exposure is live now. Federal investigators don't need to wait. The tape is authenticated and in the record. A senior Trump legal advisor who issued a public statement in January flatly denying Trump's involvement in the communications captured on the tape. Their situation before? Credible, respected, insulated by attorney-client relationships. Their situation now? Their public statement directly contradicts authenticated federal evidence. Their situation in 30 days, facing bar review and potential obstruction inquiry. Not for what their client did, but for what they said publicly. Elected officials who went on record, on television, on the Senate floor, in committee hearings, vouching for the version of events the tape now demolishes. At minimum, 8 senators and 14 House members made specific public statements that the tape directly contradicts. Every clip of them defending that narrative is now campaign material for their opponents. Committee chairmanships built on the credibility of that narrative are now politically unstable. The 2 senators who broke from Trump on Friday didn't do it out of conscience. They saw the tape and did political math in under an hour. They believed the evidence would stay buried. Pam Bondi was supposed to be a loyalist. The release was not in their model. A Senate Judiciary member who testified in a committee hearing that the communications in question never happened at the level being alleged. That hearing is now being replayed on a loop with the tape audio underneath it. The legal and financial structures surrounding Melania Trump's independent ventures, foundations, licensing agreements, and brand partnerships established during and after the White House years. 3 registered entities, multiple licensing partners, an unknown number of contractual relationships now under scrutiny. The tape apparently includes references to decisions made through or around those structures. Investigators looking at the tape aren't just hearing personal conversation, they're hearing operational discussion. Financial compliance reviews now extend into territory the entities believed was completely separate from political exposure. Licensing partners received legal counsel notices Friday afternoon. At least 2 are reviewing their agreements. Melania's business structures were set up specifically to maintain legal independence from Trump's political and legal orbit. The tape collapsed that separation. A European licensing partner who signed a 5-year agreement with a Melania-affiliated entity in 2024. By Friday afternoon, their general counsel had issued an internal hold on all payments pending legal review. See who this actually hits? Like this breakdown. Conversations between spouses carried a presumption of privilege, both legally and in terms of prosecutorial restraint. The unwritten rule was that a spouse's private communications were off limits unless extraordinary circumstances demanded otherwise. Once a tape like this exists in federal evidence, authenticated, chain of custody intact, spousal privilege arguments collapse if the conversation touches a third-party legal matter. Melania's attorneys argued privilege. The judge disagreed in writing. That written opinion is now precedent. The ruling is in the federal record. Every future attorney advising a politically exposed spouse now has to read this decision before telling their client that private communications are protected. Future president's spouse discusses policy, business, or legal strategy with their partner privately. Before this, protected. After this, only protected if the conversation is purely personal and touches no third-party legal matter. A line that just became razor thin. Political loyalty to the administration that appointed you would shape how former officials handled sensitive materials after leaving office. Pam Bondi released this tape. She was appointed by Trump. She authenticated it, cleared it through proper channels, and released it in the public interest. That rewrites the assumption entirely. Independent oversight gained power. Public accountability gained power. Future prosecutors who can point to this release as precedent for acting without political cover from above, they gained power. The assumption that political appointees protect political allies after leaving office, that lost everything. Future administration appoints loyalists throughout DOJ. Those loyalists leave office. The Bondi precedent now means their successor officials, or they themselves, can release materials that damage former allies. Loyalty has an expiration date. Evidence in sensitive federal matters stayed locked in legal proceedings. Public release required lengthy court battles. The default was secrecy. When release serves the public interest and proper authentication is documented, Former DOJ officials have demonstrated they can move evidence to public record quickly and decisively. Every politically sensitive investigation now operates under the assumption that evidence can surface publicly, not just through leaks, but through official, authenticated release. Future case involving a high-profile political figure. Their attorneys can no longer assume evidence stays buried in the system. Bondi just showed how it comes out. These aren't overreactions, these are structural. Every potential 2028 Republican primary candidate is now doing the same calculation. How closely were they tied to the narrative the tape destroyed? At least 3 potential primary contenders distanced themselves from Trump's statements on this matter within 24 hours of the tape's release. Donor calls are being rescheduled. Major GOP fundraisers are waiting to see how this develops before committing to anyone. Every current and future first spouse, regardless of party, now operates under a fundamentally different legal reality because of this ruling on spousal communications. White House counsel offices will now conduct spousal communication briefings that previously didn't exist. Future first spouses will be advised to route any non-personal conversations through counsel, changing the nature of the role entirely. The tape validated years of reporting that was publicly dismissed, editorially questioned, and legally challenged by Trump-affiliated entities. The reporters who broke elements of this story 3 and 4 years ago are now being cited in federal proceedings. Some are being called to confirm sourcing in ways that put their source protection privileges under pressure. A journalist at a major outlet who published a piece in 2022 about the communications now captured on tape, their editors suppressed a follow-up. The tape just proved the original story was right, and now federal investigators want to know how they knew. The ripples spread outward in waves. One 18-minute tape affects Trump's legal exposure, which reshapes Republican politics, which changes how future White House spouses operate, which puts investigative journalists in legal jeopardy. 4 degrees of separation from a single recording. This reaches further than you thought. Stay with me. All external public statements from Trump attorneys paused pending internal review. New communication protocols reportedly being implemented, encrypted, attorney-client protected channels only. At least 2 law firms retained as outside counsel to the outside counsel, an extraordinary legal buffer. The tape revealed that previous communication assumptions were catastrophically wrong. Every statement made before Friday is now a potential liability. A prominent Trump-affiliated law firm sent internal guidance to all partners within 6 hours of the tape's release. Nothing on this matter goes external without 3-layer approval. Rather than defending or attacking, House and Senate leadership went into procedural mode, requesting briefings, calling for proper process, avoiding direct statements about tape content. If they don't say anything specific, they can't be directly contradicted by whatever comes next. Short term, yes, the silence buys time, but silence has a shelf life. Committee hearing requests are already in motion, and they'll have to speak eventually. Everyone's building legal buffers and communication firewalls. Nobody's addressing the underlying reality. The tape exists, it's authenticated, and more materials are reportedly queued behind it. That gap is the next problem. Procedural caution doesn't change what's on the recording. Everyone's focused on how this damages Trump. Nobody's noticing that Melania's legal exposure is entirely independent of her husband's and potentially more acute in specific areas. Joint defense agreements between spouses have limitations. If prosecutors determine that Melania's interests and Trump's interests diverge, and the tape suggests they might, the legal strategies that have kept them unified for years begin to fracture. A joint defense agreement assumes both parties benefit from the same legal outcome. The tape apparently captures a moment where their interests were not aligned. That's the kind of detail that splits legal teams. While Melania and Trump absorb damage, Bondi is quietly repositioning. By releasing the tape as a former DOJ official acting in the public interest, Bondi has separated herself from the loyalty narrative without appearing to betray anyone. She released evidence. She followed process. She let the tape speak. The Bondi betrayal framing is too clean. The reality is more strategic and more interesting. The debate is, how damaging is the tape to Trump? The actual question is, what else exists in authenticated federal storage that hasn't been released yet? The 18-minute tape may not be the most significant piece of evidence in this matter. It may be the one they released first because it was the easiest. Federal evidence storage in matters of this scale typically contains hundreds of items. One tape getting released means the dam has a crack in it, not that it's empty behind the wall. These angles matter because they change the entire timeline of what's coming. Like if you're starting to see the bigger picture. Legal teams on all sides absorb the damage, build new frameworks around the tape's existence, and the matter eventually resolves through plea or civil settlement without additional criminal exposure. The tape becomes historical, significant, but bounded. No additional authenticated material surface. Federal investigators determine tape is the ceiling of available evidence. Political will to pursue further diminishes over time. Probability? 20%. Historically, cases like this generate one major evidence release. Then the system slows down. Possible, but Bondi's statement suggested more materials exist. Trump's attorneys contain the damage. The Republican Party moves past it. Melania's exposure stays bounded. Accountability advocates lose. Investigators who believe more exists, they lose too. The 18-minute tape is the first of multiple authenticated evidence releases. Each one lands on a news cycle. Political pressure builds unevenly. Some Republicans break, others dig in. Legal proceedings expand. Trump remains politically active, but legally embattled. Resolution takes years. Additional materials in federal storage are cleared for release. Bondi or successor officials continue methodical public interest releases. Courts continue denying suppression motions. Probability? 60%. This is the pattern. One release tests the system. The system holds. More follow. The Bondi precedent makes each subsequent release easier to justify. Federal investigators win. Opposition political figures win. Investigative press wins. Trump's inner circle loses. Republican incumbents in competitive districts lose. Melania's business entities lose. Trump's legal team finds a procedural mechanism to challenge the release framework itself. A higher court intervenes, creates new precedent, restricting former DOJ official evidence releases. Remaining materials get locked back up. The tape remains, but loses context without surrounding evidence. An appellate ruling that the Bondi release process was legally flawed. Enough Republican-appointed judges on the relevant circuit to create favorable precedent. Probability, 20%. The legal theory is available. Whether it works depends on specific circuit composition. Trump's team wins. Future administrations who want evidence locked away, they win too. Accountability mechanisms lose. Public access to authenticated federal evidence? Gone. Current trajectory suggests scenario B most likely. But a successful appellate challenge shifts everything towards scenario C and fast. Subscribe. I'll track exactly which scenario unfolds and when the next release happens. A period of escalating legal motion activity over the next 30 days. Suppression attempts, discovery challenges, appeals. Statements from Trump himself that contradict the tape, followed by legal scrambling to explain the contradiction. Watch the docket, not the press conferences. What gets filed in court is the real story. What gets said on television is noise management. Follow the attorney withdrawal notices specifically. When lawyers leave a case, they know something. Don't assume the tape is the whole picture. It was released because they were ready to release it. The question is what they're still holding. Donor pressure to take a clear position. Silence becomes harder to sustain past the next news cycle. Opposition research teams have already built full ad campaigns around this. They're waiting for the right moment. Get ahead of it with a clear, legally accurate statement that doesn't overclaim. Waiting for full facts is viable for approximately 2 more weeks. Then it becomes a position itself. Audit your own public statements from the last 18 months for anything that now looks problematic. Don't repeat specific claims that the tape contradicts. That's the trap that catches lawmakers, not the tape itself, but their own previous statements. Regardless of political position, the precedent around spousal communications and former DOJ evidence releases affects everyone, not just this case. Watch whether additional authenticated materials surface in the next 30 days. That's the clearest signal of which scenario is unfolding. Watch the congressional response, specifically whether oversight committees act or perform. Reassess in 30 days. The next evidence release, or its absence, tells you everything about where this is actually going. Trump's legal team files appellate challenge to the release framework. Congressional oversight committees hold hearings or visibly avoid holding them. Melania's attorneys either restructure the defense or begin settlement conversations. May 22nd, deadline for Trump legal team to file appellate response to the denial of their suppression motion. June 2nd, Congressional Oversight Committee hearing on former DOJ evidence release protocols, already scheduled before this tape dropped. These determine whether the legal counterattack has a viable path and whether Congress treats this as oversight or theater. Either additional authenticated materials surface, confirming scenario B, or silence suggests the tape is more isolated than Bondi's statement implied. Watch Trump's own public statements, specifically whether he addresses the tape directly or continues deflecting. Direct engagement signals a legal strategy shift. Watch Republican Senate behavior in the next 2 major floor votes. Loyalty to Trump on unrelated issues signals the tape hasn't broken the coalition. Defections signal it has. The appellate outcome on the release framework shapes everything. A ruling in Trump's favor locks future evidence away. A ruling against him opens the door wider. By the end of the year, we'll know whether Bondi's release was a one-time event or the beginning of a sequence. We'll know whether Melania's legal exposure remains connected to Trump's or separates into independent proceedings. And we'll know whether the spousal communication precedent gets codified or challenged into reversal. The 18-minute tape isn't the story anymore. The story is whether authenticated federal evidence can now move from secured storage to public record, and what that means for every powerful person with materials sitting in that system. If the answer is yes, we are watching the rules change in real time. I'll keep tracking the docket, the evidence releases, and the attorney movements as this develops.